You're very much welcome, everyone, to this NOUS seminar today. And we have the pleasure here to have Dr. Rick Wendler as our speaker. And Rick has written an extremely interesting doctoral thesis, Law as Spontaneous Order, an Evolutionary-Emergent Understanding of the Legal Order, starting with the scholastics and moving forward, actually. And Rick has studied law at the University of Jena and also at Trinity College at Dublin. And he also has been a scholar at the Friedrich Naumann Foundation and an Adam Smith Fellow at the Mercator Center at George Mason University. So without further ado, I will leave the floor to you, Rick, and you have 15-20 minutes, and then raise your hand and we will have time for Q&As. So please go ahead, Rick.
Thank you very much, Nils, for this kind introduction. I'll try to be as short as possible to leave as much space for the discussion as possible. So yes, law as a spontaneous order, the obvious questions, of course, being what is it, a spontaneous order, and what has it got to do with law, with legal theory? The textbook definition of spontaneous orders generally refers to 18th century Enlightenment thinker Adam Ferguson, who of course did not use the term spontaneous order yet, but when he was pondering what he's actually doing there with his social theory, he said that he is examining social orders that are the result of human action, but not the execution of any human design. And that's, you know, the core of the spontaneous order theories, the result of human action, but not the execution of any human design. And of course, the best known example of spontaneous order is the market economy, which emerges out of the interactions of millions of individuals whose behavior is coordinated by the price mechanism and who are thereby able to adapt to each other, you know, by having communicated those specifics about supply and demand. And this order is of course not designed by any superior authority top down. And this provides more or less the basic understanding of a spontaneous order, as Hayek elaborated most famously with the market being a coordinating and knowledge processing institution. And there's a commonplace among spontaneous order scholars that this does not only apply to the market order, but to other social orders that emerge spontaneously too, being, for instance, morality or language or the law, what I am talking about. But then the problem arises, how does this then work? Because it's obviously not just an analogy to the market, because in morality or language or law, there are no prices, there's no supply and demand. And so it's not as obvious how this coordination there actually works and what kind of knowledge is processed there. And then it turns out that, for instance, the law has more similarities to for instance, language than it has to the market order, because it is not about the short-term knowledge of specifics, but rather about the long-term knowledge of abstractions. To use a more contemporary image, where the market is, so to say, the computer processor of the short-term knowledge, the language and law are more the hard drive, where knowledge is stored for a long time and generated over generations. And one of the first to elaborate on this with respect to language was German Enlightenment borderline romanticism philosopher Johann Herder, who in his linguistic philosophy pointed out that is by our everyday use of language that every individual contributes to the storage, and that we, by our everyday use of language, decide what is kept in the storage, what is added to it, and what is abandoned by simply not using it anymore. And this refers also to one of the examples Hayek gave when he said that, for instance, the Inuit, the people living in the polar region, they're having a dozen of different terms for snow, because for their everyday survival over generations, it was relevant to differentiate between all different kinds of snow, I guess, referring to the consistency, density, freshness, and whatnot. I don't know. Where on the other hand, the Aztecs in Mexico, they had one single word equally describing snow, ice, and cold, because it never was relevant to them to make those differentiations. So this is how, out of the necessity of a functional communication, every acting individual becomes a co-creator of this overall order. And I think it's important to note that this even applies, already applies to languages, that a social order that is as complex as a language, it cannot be designed from scratch or designed top down. It's not that this has not been tried. You know, the project of logically constructing a universal language is centuries old, and one of the more lately, or more of the recent tries has been this Esperanto. Maybe you've heard of this, and this was the attempt to strictly logically construct a language that can be learned by everybody all over the world and used. And it turns out it's not used really by anybody for communication, because it's not functional. It does not work, because that's not how language emerges and evolves. And so this is one of the key insights, that those theories of spontaneous orders always have been a criticism of this naive constructivist rationalism that tries to just design social institutions from scratch. And so it is out of the interaction of the people that a language evolves over generations, often over millennia. And this is why Hayek called this the twin ideas of spontaneous emergence and the evolution of the social order. And I think we might come back to this in the discussion at the latest point, when we see that it's not only possible, but we also should distinguish between the spontaneous emergence and the evolution aspect of those things. Having said all this, what does it mean for law and the legal order? I'd say in this sense, the legal order is an abstraction of functional normativity. So it is clear from an anthropological perspective that the social context is the human condition. There have never been humans outside of any social context. So all theories of a natural state of isolated individuals might be theoretically interesting, but they have no connection to the real evolution of society. But that means at the same time that there can be no society without a normative frame, without rules about what to do, or more precisely and more especially about what not to do. And because that is whenever people get together, there's conflict. It's inevitable. I'm sure all of us know this. And a society would not sustain for any meaningful time without normativity included, without rules. And those rules might have been at the very beginning implicit, unverbalized, formal rules. But when there are conflicts and they need to be settled, those conflicts will be verbalized, and the settlement of this conflict will be verbalized as some sort of hypothesis of justice. And then later on, we tested this hypothesis. Is it actually suitable to solve the conflict? Is it suitable to prevent future conflicts? And it will be reapplied to future similar cases, and might be necessary to adapt it, to reformulate it, or to even get rid of some of those, and only a hypothesis that stands the test of time will become an established principle of justice. And this is basically how judge-made law, case law is established, on which the common law system is based, as opposed to the continental European legal systems that are more based on codification and legislation. That's what Michael Polanyi described in detail, how a judge deciding a specific case refers consciously and unconsciously to dozens of previous precedents, and when the judge then decides the case, this becomes a new stimulus to which judges in the future will have to adapt. And this is how, out of the interaction of the legal subject, emerges and evolves a legal order without being designed by superior authority. And so the emergence and evolution of the law is a constant struggle. There are always conflicts going on, and this process will never end. So it's always that's what differentiates the law from language. Language just evolves by adopting new things, new vocabulary or grammatical structures, or abandoning them. But it's not so easy within the law. It's it's always struggling with each other. People who are feeling that their rights are being infringed, they pick up this conflict and thereby provide new input for the legal order that is then being processed over the course of years, centuries, millennia. Yes, and this often seems to be counterintuitive, especially in the more continental tradition, where the predominant perspective of legal positivism focuses on the legislative design and the already formalized legal order. So they from this perspective, the analysis starts when there already is a formalized law. And to be fair, it is only possible to have this clear distinction between spontaneous ordering process on the one hand and legal design on the other hand, because in reality nowadays it's a mix. Of course there's legislature, there are processes of purposeful design top down, at the same time spontaneous processes bottom up, and then of course the question why when it's only in theory that we can distinguish it, why bother with it at all? But I'm convinced that it's not just of purely intellectual interest. This is not a problem of the ivory tower, because it matters from which perspective we look at it. And I guess it's true for all social sciences that when we look through different lenses, we see different things. And this determines how we respond to challenges, and the challenges for the legal order of our time, at least the biggest, I would say, are how to deal with this increased social dynamics, with the ever faster social change and with the increased complexity of our globalized world. And it does make a difference if we approach those challenges from an cooperative understanding of law as coordination, or from an authoritative understanding of law as subordination. And the question remains, how do we adapt to changes? How do we manage such a degree of complexity? And this perspective I've presented suggests that the higher the degree of social dynamics and complexity, the stronger gets the reliance of those spontaneous ordering processes, because this takes into account the dispersed knowledge of all acting individuals, it allows for parallel hypothesis testing, whereas on the other hand, legislation requires some form of centralized body that dictates top down what the law is. And this alone is an immense reduction of complexity. I mean, Germany, the German federal parliament, is one of the biggest in the world, but it's still got only 700 members, and 700 compared to the millions that interact every day is an immense reduction of complexity. Again, to be fair, of course, the democratic process of deliberation can be seen as some sort of knowledge processing mechanism, but the question remains, where do we get the informational input from that is being processed in the legal order? Is it top down or bottom up? And for legislation, the forum of the parliament is rather exclusive, because the parliament is limited to a very tiny minority, whereas the forum of the legal order, the courtroom, is open to anybody who feels affected by basically whatever. You are free to argue your case, and you have a much more direct influence. It's very limited scale that you have influence on, but it's direct influence, whereas in the broader democratic deliberation, you have very, very indirect influence with one vote in a million every 4 or 5 years. So these are things that can be taken into account there. And so I'd argue that it can be beneficial when we are facing the social challenges of our time to take into account the perspective of spontaneous orders, especially to legal theory, when we are trying to provide an abstract frame of normativity in which the individuals are free to adapt to each other, and we rather not try to regulate every minute detail of everyday life, such as the maximum power vacuum cleaners, or most recently the type of engines that can be used in cars, etc. And I notice I'm running out of time, so I will leave the aspect of institutional competition, which is another highly relevant field, to the discussion. Just mentioning that the current trend of the ever closer union of the harmonization in the European Union is the opposite of enabling institutional competition, and thereby leave it to the legal subjects to decide by mutual adaptation which kind of order they prefer. And I will close on the remark that I think it's important to understand that spontaneous ordering is not the same as pure laissez-faire. It's not about simply idly leaning back and watching, but it's rather about cultivating this institutional arrangement in which the people can make best use of their spontaneous ordering, adaptive capabilities. And this is what I think the Ostroms meant with their art of association. For that, I'll thank you all for your attention. Thank you.